Now we wait for another 1 minute, one more minute, and then we will start. Welcome to Humayun, welcome to Abigail, welcome to Pierre, welcome to Collins. Yes. Now, can you all hear me well? It is 3 minutes past 3 and we can start. My name is Dignité Bouiza-Visser and I'm a member of the ICCBA Training Committee, and I'm pleased and honored to welcome you to this event. This is a book presentation, but before I explain which book it is and why, I would like to remind that today is the International Justice Day, and that this activity is held in celebration of that International Justice Day. Now, we will discuss, as the flyer mentioned, the book The Nazi and the Psychiatrist, and we will discuss it from a defense perspective. What can defense lawyers, practicing international criminal law, what can defense lawyers learn from the experience of the Nuremberg trials, especially from the book The Nazi and the Psychiatrist? And we will start with the intervention of Jekyll Hyde, who is the author of the book. It will be followed by the presentation by Jean-Pierre Jacques, who is a defense attorney who practices international criminal law and who currently has the case as a defense attorney in international criminal law. And we will have 20 minutes at the end with a presentation with questions. So you can, if you have questions in the meantime, you can write them in the chat, or you can ask them later when we are done. Now, a biography of Jekyll Hyde. Jekyll Hyde is an author, he's a journalist, and he's a journalist who writes nonfiction book, articles, and essays. He covers medicine, history, science, and crime. Among his published books are the New York Times bestselling The Nazi and the Psychiatrist, The Lobotomist, The Lost Brothers, and Face in the Mirror. Jack is a past president of the American Society of Journalists and Authors, and he is a two-time winner of the June Roth Award for Medical Journalism. And you can find more information on his biography that was shared on the ICCBA website, but also online you can Google him and find him. And I would like to pinpoint that this book, this is the one we're discussing today, was first published in 2013. And then you would ask why talk about it today, because last year in 2025, the book was, a movie was made inspired by the book. It's available online and on Netflix and on other platforms. And what is interesting is that it remains relevant even 13 years after its publication. And I heard that this summer there will be a new translated version in French. So for those who read and speak French, you are welcome to read the new printed version in French. Now, without further ado, Jekyll Hyde, the floor is yours. You have 15 minutes.
Okay, thank you so much for that nice introduction and welcome to everyone attending this meeting. I'm very grateful to be invited, especially on this day and what it means. And thank you to all of you attending as well. I wrote The Nazi and the Psychiatrist, published in 2013, as a result of very luckily coming across some records and documents that had not been previously available to scholars and writers. A few years before, I had been in touch with the son of Dr. Douglas Kelly, who is the subject of my book, and I asked the son if he had any materials relating to his father's career. And he said yes, and he invited me to come to his home in California to take a look. I did, and was astonished, overwhelmed, etc., to find out that the son brought upstairs from his basement 15 banker's boxes full of materials of all kinds, that most of which were materials that his father had brought home to the US from Nuremberg when Dr. Kelly returned home in 1946. And I spent a great deal of time, many return visits, looking through these materials, and saw immediately that they could be the basis of a very interesting book on a subject that I had previously known little about. And that was a side of how that international military tribunal, the first of the Nuremberg trials, in which 22 members of the German high command, both military and civilian government leaders, were tried for war crimes, crimes against humanity, and other charges. And to see this from the perspective of a psychiatrist who was brought in by the court to assess the mental fitness of the defendants seemed to me a really interesting perspective on that trial, which of course has been written about many times from various other perspectives. And as I went through the materials, I kept growing more impressed with what was there and what had been kept out of the public eye for, at that point, about 60 years. So what I learned about Dr. Kelly was that he was born in California, attended medical school at the University of California, and at the start of the start of the U.S. participation in World War II, he was assigned, he had enlisted in the U.S. Army, assigned to work in a series of field hospitals in Western Europe, treating soldiers who suffered from what today we would call PTSD. And so when the war ended, he was there still, and he was of relatively high military rank and had a very good professional reputation as a result of the work he had done during the war. And so he was summoned. He didn't know what exactly he was going for. Summoned initially to Luxembourg, to a town called Mondorf, where many of the defendants were initially being held, and then they were later all moved to the prison in Nuremberg. And for Dr. Kelly, assessing the mental fitness of these defendants was a relatively simple thing for a psychiatrist of his experience and skills. I say experience, he was only 33 years old when all of this began, but he was still quite experienced already. He had no previous experience working with defendants charged with war crimes, anything like that. And but Dr. Kelly knew that this was a once-in-a-lifetime opportunity for a psychiatrist. Many other psychiatrists from many nations would have gladly traded places with him to be among these men who already were being regarded as some of the most notorious defendants of the 20th century. And so Kelly very quickly assessed the defendants for their mental fitness. He found that all of them, except one, was probably mentally fit to stand trial. The one who was not committed suicide before the trial began. And so Kelly needed another reason to satisfy his own curiosity and his own professional opportunity here in Nuremberg. And he decided to set up for himself another more ambitious project, which was to assess these defendants to find out whether they shared a common psychiatric disorder that could account for what he believed were their heinous crimes and terrible behaviors before and during the war. And he assessed these men over the next 8 months in a variety of ways, in large part by interviewing them individually. He spoke with all 22 of the defendants at great length, in some detail. And he also gave them a battery of psychiatric assessments, 3 different tests. And he had completed this work to his own satisfaction by January 1946. At this point, the trial was ongoing and would be going on for another 8 months or so. But Kelly believed that he had seen enough and was discharged from the US Army, returned back to the States with his conclusions. What were his conclusions? He concluded that there was no shared psychiatric disorder among these men. Furthermore, he concluded that except for the one, Robert Lay, who had committed suicide before the trial, none of them had any kind of serious psychiatric disorder. And so Kelly's conclusion was that these men all fell within the normal range of human personality and behavior. In a sense, they were ordinary men, at least in a psychiatric sense. In his opinion, they were ordinary men. This was greatly disturbing to him for a couple of reasons. One reason was it meant that his medical specialty, psychiatry, could really not account for people like this who were accused, and most of whom were convicted, of committing barbaric, horrifying, terrible crimes not before seen in human history. And that caused Dr. Kelly to change his own professional orientation a bit. He moved closer to another discipline that he thought perhaps could explain people like this if psychiatry could not, and that was criminology, a social science. And so he spent the last years of his career as a professor at the University of California, not of psychiatry, but of criminology. But the other reason why his findings about these men disturbed him was that if these men were indeed normal, in a sense, that meant that there were likely many other people among us out there like them who could commit, who were capable of committing horrible crimes like these. And Kelly never believed that everyone is capable of committing crimes like these, but he came to believe that there is a significant percentage of our population in every country, all over the world, in every era of time, who, given the opportunities, could commit crimes like this. And so Kelly's time among the defendants changed his perspective on his own country. He came back to the United States, and whereas he had probably previously not thought a great deal about it, he saw political events in the US, especially in the southern states that were racially segregated, as being similar to what he had heard from these defendants and learned about life under Nazism. And he began to speak out against especially the Southern politicians, how they conducted their political campaigns, how they gained the support of the white citizenry, and especially how they used propaganda to emotionally manipulate voters. Kelly's, the remainder of Kelly's life is tragic. Because, as I said, he went to work at the University of California, but he began to go into a personal downward spiral and suffered from alcoholism. He was in a very troubled marriage, marriage that was in which he behaved at times violently toward his wife. And he, as I learned from his son, was a very difficult father to grow up under. He felt persecuted by the US government during the McCarthy anti-communist era of the 1950s. And in 1958, Dr. Kelly took his own life, strangely, in the exact same way that the defendant in Nuremberg that he had spent the most time with, Hermann Goering, who had been the highest ranking of the 22 on trial. He used the same method of suicide, ingesting cyanide poison. And so I had the opportunity to get a glimpse inside of Dr. Kelly's mind via all of these extensive documents, also through the experiences of his son, who had a very good recall of what life was like growing up with his father in these later years. And all of that led to the book. And if there are lessons for defense attorneys in the book, one may be that that if these men, if people who commit crimes like this are normal, in a sense, then that means that they can be held responsible, and that a way to adequately defend them may be to probe into other aspects of their background, motivations, or to try to establish that that they're not responsible for the crimes, but that the path of not being mentally fit, of suffering from psychiatric disorder, at least if you can generalize from these 22, may not be the way to go.
Thank you very much, Jack. Thank you. If you have questions, please do not hesitate to mention them in the chat, and Jack will answer them later. We're going to proceed with the presentation of Jean-Pierre Jacques. Jean-Pierre Jacques is an attorney. He is a member of the Liège Bar Association since 1999, and he is also a member of the Rwanda Bar Association since 2015. He teaches international humanitarian law at Helmo in Liège and at University of Mons. And he is a member of CCBE. It's in French. I don't know the translation in English. He has 25 years of experience in international private law and immigration law. And in terms of international criminal law, in 2019, Maître Jean-Pierre Jacques was the defense counsel of the first person accused of genocide crimes in front of a Belgian court in Brussels. And in 2027, which is next year, he will defend once again a defendant accused of genocide crimes committed in Rwanda in 1994. And he will do that in front of Belgian courts. Welcome, Jean-Pierre. You have 15 minutes to tell us about what a defense counsel practicing international criminal law and what lessons a defense counsel can learn from this book and from the experience of the Nuremberg trial. Thank you, Jean-Pierre.
Hi, everyone. Thank you very much, Dimitri, for your presentation and this meeting. I'm very glad to speak with you about that specific topics about the influence of a Nuremberg trial today, because it seems sometimes for lawyers that Nuremberg trial seems to be very old trial, the first international trial with all the defaults of the first international trial. As for example, the fact that it was a trial made by a military court organized by victors of state victories of the conflict. So there is a lot of criticism about the first Nuremberg trial. But what is very interesting is the actuality of this trial regarding the specific intention of the defendant when they are committed some crimes. And that's exactly what Dr. Kelly in the books written by Jack could enlighten exactly. Precisely, it's the fact that in law, when you have a trial and you have specific offenses like mass crime, we have a genocide, a crime against humanity, or war crime. It's not the question of in which intention they did it. Of course, we know that the specific elements of the crime, which are part of the definition of each crime. Here it's much more something on the personal psychological profile of each defendant, which is important to underline. For example, in the Nuremberg trial, what was very interesting is that Kelly was mandated by the tribunal to, first of all, check whether or not the defendant were capable to be judged, to be trialed by the tribunal. So it was just a question of are they mentally sane to be trial or not? And what is interesting to read in the book, in the Jack's book, is that the mission that finally Dr. Kelly's just decided to do was broader than what he was initially mandated to do. He wasn't doing only a specific investigation regarding each defendant. He tried to find whether or not there were shared psychiatric disorder by each of the defendants, which was not the mission he was mandated to do at the origin. And that's very interesting to see that Dr. Kelly has another thing in mind. He was ready to enlarge the consequences of the mission he had, to try to find whether the defendant has maybe a common psychiatric disease, in order that they were capable to commit some kind of this horrible murder. And that's also exactly the lesson we have to draw from this experience, because it shows us that when you have expert in a trial, you have to be very careful as lawyers, even if you are defending whatever the party you are defending. You have to be aware that they have a mission and they have to stick with the mission regularly and strictly to the mission they have dedicated to them, which are dedicated to them. Otherwise, they will have a sort of new judge. They will endorse a role which is not the role they have to play. And that's the danger of giving some mission to experts. And we have to be very careful as a lawyer when an expert say something to check whether what he's saying is one part of his core business. Is he expert? Is she expert in the mission he's dedicated to? And secondly, what he's saying in its report, in the conclusion of the expert, are the conclusion in are they fitting with the mission that the tribunal mandate today? And that's something which is quite difficult sometimes to appreciate. First of all, because we are lawyers, we are not experts, especially when they are expert in the medical field, for example. It's sometimes difficult to know exactly what are the effect of what they will conclude. Another thing also, which is very important, is to understand correctly the conclusion of an expert, specifically when you defend someone who makes some eventually makes some declaration to the police during interrogation, for example. We have noticed that the psychology, some psychology studies demonstrate that there is some element which can influence, which can have an incidence in the way that a defendant will respond to police investigation, for example. And that's exactly what another psychologist did remarks, which is Milgram, when he made some research regarding the question of obedience experimentation he made, and the fact that he had to check how an authority can pursue you to obey to some illegal order eventually. And what the conclusion, for example, of Milgram is that a very high proportion of subjects would totally obey to instruction to arm people, whether the instruction is totally illegal, and even if they are initially reluctant to obey. That's something which can lead to misinterpretation, and it was shown with the Milgram's obedience experience that sometimes a range of social influences for individuals can mislead to interpretation of the situation. For example, it includes how police interrogators can get innocent people to confess to crime that they did not commit at all. Why? Because they are influenced by the authority that police investigators represent for them. And on a certain point, they are ready to obey to the instruction, even if they have not committed some crimes. The conclusion of that is that we have to be very, very careful when we use the conclusion of an expert. For example, no, it's quite clear that the context in which an investigation is made and some interview are made by the police can have significant consequences for the defendant, and specifically when there is a context of non-explicitly reference to authority. And that's why main of the investigation should be recorded, video recorded, to be sure that the context in which the investigation has been made by the police are made without any indirect influence from the investigator. The other thing, and I will finish by that with my presentation with that, is that obviously all we are talking about is not concerning the fact that the defendant is suffering or not of a mental disease. It's clear that if we take, for example, the ICC statute, there is provision in the ICC statute regarding first the intent in which the fact are committed. The criminal must committed the crimes with intent and knowledge. It's Article 30 of the ICC statute. And for the grounds which could exclude any criminal responsibility, the first one, which is mentioned in Article 31, is the fact that the person is suffering from a mental disease. On that aspect, the mental disease of someone, it's clearly a case in which there is no possibility to have a trial against the person, because the person is not capable to be trial on that point, or is considered at the moment of the commission of the fact as insane, mentally insane, in order that he didn't have any consciousness of the gravity of the fact that he has committed, of the wrong and the right, or the fact that he has committed. So on that point, that's not the debate here. The debate here, it's a debate about what can we do with conclusion of experts. And Kelly's experience during the Nuremberg trial, it's very interesting on that point. One, because it's clear in the book, first in conflict of interest. Why? Because he was mandated not only by the tribunal, but the conclusion he gave was given first to the prosecutor, which means that it's obvious for us today, but at that moment it wasn't. The conclusion he gave was given to help the prosecutor. Thank you. I will finish in 5 minutes, don't worry. And on that point, it's a real disbalance between the parties in the process, and a breach of the balance between the parties in the process. This could be avoided today with the ICC proceeding, which is clearly much more fair than the Nuremberg trial could be. But I just suggest to be very, very, very not reluctant, but at least aware of the fact that the conclusion of an expert are not neutral at all. They are given in a sense that it could be useful for you, for the defendant, or for the prosecutor. You have to just correctly detect what are the way in which the conclusion made by an expert can have a consequence, an incidence on that point. And I will finish just to give you my main lesson from the Nuremberg. It's about the fact that as Milgram said, and we had exactly the same with the thesis of Hannah Arendt in her book. The people who are trial and considered as, for the majority of the people, as monster are not really monster at all. When I say not really, it's that they have maybe committed facts, offenses which can be disgusting and monstrosity, but people who are doing that are, as Jax explained, and Dr. Kelly explains also in investigation, are ordinary people, and that's maybe the worst thing we could have as a conclusion, is that as you, me, and anyone could lead in certain circumstances to provoke exactly the same result that our defendant or clients are guilty for sometimes. I thank you very much for your attention.
Thank you very much, Jean-Pierre, for your intervention. And the takeaway I get from your intervention is that we, as defense lawyers, should always check whether and make sure that experts who come either for psychiatric analysis do not become other prosecutors or do not give information that will add on the accusations prevailing on our clients. Before I let everyone ask a question, I have a question for you, Jean-Pierre. Then would you advise your client, and you as a defense counsel, would you advise your client to undergo psychiatric or psychological tests in preparation of his trial? And would you, as a defense lawyer in international criminal law, use the lack of psychiatric evidence to discriminate or to question the culpability of your client?
According to me, depending, of course, of the context in which an expertise, a psychiatric expertise, a psychological expertise of my client would take place. But taking into consideration that, I think it's always interesting to have such an expertise, such a conclusion about expert in psychiatry or psychology. Why? Because there is some always in such expertise, there is always element which could help you in the way you have to defend your client. For example, the past of your client, the traumas of your client, the thing that the thing that your client have lived, have experienced, have suffered, can express maybe or explain maybe without any justification, but at least explain why at a certain point one people can do something which is considered as wrong, even if at that moment he didn't have that consciousness of doing something wrong, but he did. And for example, to make a link with the Nuremberg trial, in the Nuremberg trial, most of the 22 defendants were hierarchic superior. So they were all in a position in which they are not in the lower base of the scale. They were superior and they were issuing orders to follow. So in their situation, it's not a question of obeying or not obeying. It's a question of what I am doing, what I am deciding for my hierarchy. Is it something that I have conscience of or not? And my psychological profile can give an explanation for me as a lawyer about what you have done and what you were capable to do at that moment.
Thank you very much, Jean-Pierre. I will start with Yoon Kyung Lee. Yoon, can you ask your question? He asked a long question in the comments, but Yoon, can you please ask your question verbally and tell us if it's directed to Jean-Pierre or to Jacques Elham?
Hello. Can you hear me well?
Yes, we can hear you. We can hear you. Go ahead,
thank
please.
you very much. I'm so sorry for the noise, background noise. And I'm Jin Kyung Lee from South Korea, and I'm international public health and pharmaceutical studies scholar. And at the same time, I'm studying international human rights law. And also, I'm a human rights advocate for sentencing of crime and serious and non-organized crime. And first of all, thank you so much for the conference today. And I believe that this will become really an important time for the advance of social and legal justice, reflecting the Nuremberg trials, the neo-Nazism. And I want to emphasize that there are millions of victims who are suffering from illegal human atrocity experiments, particularly in psychiatry. And they are usually tortured and abused by electronic and electric weapons and arms, and with technocrats using microchips and brain interfaces that are usually planted without any consent and even after disagreements. And they are usually being connected to the neural network AIs. And some victims include minors and children victims. So you can find them easily on the website, and then they're suffering. So this seems like in the international law, there are not many people who are discussing it. So I want to raise a question that how can international law overcome heuristic and parsimony crimes, which highly and easily pay serious and organized crimes that are actually targeting psychiatric, like mental illness, even though they don't have, but they are actually aiming to make them disease so that they can exclude as they can be excluded, they can be excluded from witnesses and the testimony in the legal justice. And at the same time, I want to also have a question that how the international attention on mental illness of those who conduct illegal tortures and experiments regulate the abuse of financial sources can be identified. And the last one is how the repeated crime of the SS soldiers to modern day brain interface or microchip or technology related crimes can be prevented and prohibited. So thank you very much.
Dr. Hai, do you have a comment or in?
These are very interesting questions, and I'm afraid they're beyond my expertise and knowledge. My focus was on Dr. Kelly's work at Nuremberg. I previously wrote a book titled The Lobotomist, and that is about surgical techniques to achieve psychiatric results, some of which were abusive. But my research on that book ended quite a while ago and did not carry on to contemporary events or what may be happening today. So I'm sorry, I don't have expertise to answer those questions.
Okay. Thank you, Jack. Is there anybody else who has a question live before we take other questions from the chat? If there's anyone who would like to ask a question live, then the floor is yours. I will leave 1 minute of to let anyone who is interested in asking a live question do so.
I will jump in here, and I did notice a question in the chat about the kind of information that Hermann Goering shared with Dr. Kelly. And Kelly's interests really among these defendants went far beyond psychiatric interests. So he discussed personal matters with most of the defendants, and especially with Hermann Goering, who was eager to explain himself. And also, Goering was using his time with Dr. Kelly to test out his thoughts for his upcoming defense in the trial. And so he would make statements justifying what he did or explaining to Kelly why he was loyal to Adolf Hitler, things like that, and see how Kelly responded. And he used that to base his own statements and his own defense in the trial later. So they did share a great deal. Kelly even shared personal information about his life with some of the defendants. This raises a lot of conflicts, as Jean-Pierre pointed out, because Kelly not only had a doctor-patient relationship with these defendants, but he also had responsibilities to the U.S. military. He was an Army officer, to the court, because the court brought him there to begin with. And finally, he decided midway through his time with the defendants that he would provide information to the prosecution. This information was somewhat helpful to the prosecution. I don't think it was extraordinarily helpful, but it did give them an idea of how Goering and a couple of the others might try and conduct their defense.
And Pamela Bros is asking whether, do you think Kelly's troubled life was related to his findings? That basically ordinary people can commit such heinous crimes without psychiatric condition?
Yes and no. I think Kelly's spiral downward and his suicide resulted from a mix of things happening in his life. And one of those things in the mix was certainly the upheaval that he felt from his time in Nuremberg, realizing that, in his opinion, psychiatry could not account for the behaviors of these men, but also that there was an imminent danger everywhere in all democracies of authoritarians rising up in the same way the German Nazis had, and thwarting democratically elected governments. And Kelly was very concerned about this, and he had other problems as well. So the question about why did Kelly choose the same method of suicide as Goering did? Again, I think that's not a direct connection, but it is an indirect connection, because Kelly and Goering were similar men who both wanted to use their suicides in a way to call attention to themselves. And dying suddenly after ingesting cyanide unexpectedly is a great way to get attention. And Goering wanted to put a thumb in the nose at the Allies, telling them he's not going to go out, be hanged the way they wanted. And Kelly was trying to tell his family and the world, his suicide was in front of an audience, that that he had been desperately unhappy for a long time, and he felt no one understood him. So there were those kinds of similarities. I don't think it was a copycat suicide, but they were similar for those reasons.
Jean-Pierre, what you mean, if I understood you correctly, is that there are still weaknesses that occurred in the Nuremberg trials in the perspective of Dr. Kelly's work, and that we should, as defense lawyer, avoid committing those mistakes again. Is there anything else you have to add, or I didn't understand clearly your point?
You didn't clearly understand my point.
Please clarify for me.
Yeah. Now, I was also reading a question of Manal El-Bari, but I'm sorry, I won't be able to answer that question, which is much more focused on the Moroccan legislation, which is topics quite specific and not really related to the topic of today's. But what I mean is that I wanted to mean is that there is still today issue with expertise coming from the tribunal. It's clear that the judge are not sufficiently well informed about medical field and medical topics. So it's normal that they delegate this kind of mission to experts. My fear is always about this kind of delegation. When I face a trial, my job is to defend someone who is accused by the prosecutor based on the clue, the evidences given by the prosecutor. And these evidence are sometimes challenged, but cannot, according to me, be totally reviewed only by an expert or by a conclusion of an expert. So we have to keep in mind that the evidence must be comforted by the conclusion of the expert, but the opposite is not possible. When an expert expresses something which is totally in contradiction with an evidence that you have in the trial, you have to be very careful with what the expert says, because the evidence is an evidence that it's submitted to the contradiction of the parties, which is not the case with the conclusion of the expert. So the expert, it's always someone who is given its opinion unilaterally. So he's the only one who's given his opinion without any contradiction. If you want a contradiction regarding an expertise made by an expert, you need to claim another expert to have a counter expertise. But it's something which is endless finally, because you have one expert which say black, another one would say white, a third one would say I think it's more black than white, and at the end you will never find the real situation. So be careful with the conclusion of an expert. It's nothing to do with evidences given by the prosecutor, and these evidences must be challenged, and the only view of an expert cannot on itself be on the same level than evidences given by the prosecutor.
Thank you. One last question, Jacques, to conclude, because we only remain with 8 minutes. Jacques, why would a defense lawyer buy your book?
To understand a little bit about how a psychiatric expert in one of the very earliest instances of an international trial of this kind conducted himself. And nowadays, if a psychiatrist or any mental health professional acted as Dr. Kelly did, that mental health professional should be sanctioned and should be criticized. And but to me, it is important that Dr. Kelly was probably the first military psychiatrist ever put in a position like this, working among people who had been accused of war crimes and being asked to assess them. And it's important also to realize that Dr. Kelly's mission that he undertook after he determined the mental fitness of the defendants was entirely on his own initiative, and that the court did not even know about it, and the prison authorities did not know about it. This was entirely to satisfy his own curiosity and then to help strengthen his professional reputation when he returned home, because he wrote a book about it, which I would recommend. It's titled 22 Cells in Nuremberg. It was published in 1947. And since the movie Nuremberg came out last year, that book has become very difficult to find. It's out of print and very expensive as well.
Okay, thank you very much, Jacques. Jean-Pierre, do you have a concluding word? But before, you as a defense lawyer, as a defense attorney who has an ongoing case of international criminal law, would you advise a defense lawyer to read this book or to read any other book similarly? Can you please answer in 1 minute?
Yeah, it's clear. As a lawyer, we need book like Jacques' ones. Why we need that? Because we need to have a look outside the book we have to use to read, which are law book, legal references, law books. All the books we are reading are regarding law. What is interesting with the Jacques book is that we have a book related to a trial, an international trial, but with the psychological view of the psychiatric of the psychiatrist of the case. So that's a sort of new view on that legal issue coming from the Nuremberg trial, which is always something very interesting for us as a lawyer to open our mind to other discipline of than the law, the strict point of view of law.
Thank you very much, Jean-Pierre. Now, I would like to thank you. Thank you, Jean-Pierre, for your insightful speech and shared experience. Thank you, Jack, for writing this wonderful book. I watched the movie, and it was, from a defense perspective, it was questioning because I was wondering what would I have done if I was a defense lawyer, if I was a lawyer for one of the 22 accused. Thank you very much to the attendees, but a big thank you to Dominic Kennedy, without whom this activity wouldn't be possible. And I remind you that this is an activity organized by the ICCBA Training Committee, and I look forward to seeing you at the next activity of the ICCBA Training Committee. And see you. Remember, the book is available online and the movie is available online.
Thank you very much.
Thank you.
Bye.
You.